Question 1. During an emergency response where multiple areas are impacted, a debtor, a retail company, has entered into a secured transaction agreement with a lender to finance its seasonal inventory purchases. The lender perfects its security interest by filing a Aquan financing statement. However, the debtor also takes out a loan from another lender who claims a purchase money security interest (PSI) in the same inventory and perfects it. Months later, the debtor defaults on both loans. In the subsequent dispute over the inventory, which creditor has the superior claim? A. The first lender, because they filed the Aquan financing statement before the PAI lender perfected their interest. B. The PAI lender, because AI in inventory has priority over a previously filed security interest if properly perfected. C. Both lenders have equal priority and they must share the proceeds proportionally. D. Neither lender has a priority claim because the debtor defaulted on both loans. Answer: B. The PAI lender, because the AI in inventory has priority over a previously filed security interest if properly perfected. Explanation: under Article 9. 324b, a purchase money security interest (PSI) in inventory takes priority over a conflicting security interest if the PSI is perfected or before the debtor receives possession of the inventory and the PAI lender sends notification to the first secured party before the debtor receives possession of the inventory. Even though the first lender filed the Aquan financing statement first, filing alone does not defeat the priority of a properly perfected ESI in inventory. If the PSI lender followed the notice requirements, it will take priority over the first lender's security interest, even if that interest was previously perfected. Option is incorrect because general priority rules, first to file or perfect, do not apply when PSI exists in inventory and the specific PSI rules are followed. Option C is incorrect because secured creditors do not share proceeds equally unless their claims are of equal priority, which is not the case here. Option D is incorrect because secured creditors retain their priority rights even if the debtor defaults. Question 2. When implementing backup procedures across various financial institutions, a bank perfects its security interest in a debtor's deposit account by obtaining control over it. Second creditor also claims an interest in the deposit account but perfects its interest by filing a Aquan financing statement. Later, the debtor files for bankruptcy, which creditor has priority over the deposit account and why? A. The bank, because security interest in deposit account can only be perfected by control. B. The second creditor, because filing financing statement provides public notice and protects priority. C. Both creditors have equal priority since they both took steps to perfect their interests. D. Neither creditor has priority because bankruptcy proceedings eliminate secured claims. Answer A. The bank, because the security interest in a deposit account can only be perfected by control. Explanation: under Article 9. 327, a security interest in a deposit account can only be perfected by control and not by filing a financing statement. Control is achieved when the secured party has the ability to direct the disposition of the funds in the account without further consent from the debtor. Option B is incorrect because a financing statement does not perfect a security interest in a deposit account. The second creditor's filing provides no enforceable claim over the deposit account against a secured party who has control. Option C is incorrect because only one creditor, the bank, perfected its interest correctly under the law. Option D is incorrect because bankruptcy does not automatically eliminate secured claims. Instead, secured creditors are protected to the extent of their perfected security interest, subject to bankruptcy rules. The bank, having perfected by control, has superior priority over any conflicting security interest in the deposit account. Question 3. While analyzing the root causes of sequential problems in secured transactions, a company grants a security interest in its equipment to a lender. The lender perfects its interest by filing a financing statement. Later, the company moves the equipment to a different state and continues using it as collateral for another secured loan from a different lender. The new lender files a financing statement in the new state. Several months later, debtor defaults. Which lender has the superior security interest? A. The first lender, because they perfected their security interest first and perfection remains valid across state lines. B. The second lender, because they perfected in the debtor's new location, making the first lender's perfection ineffective. C. The first lender, but only if they refile in the new state within specific grace period. D. Neither lender, because the security interest is lost when the debtor moves the collateral. Answer: C. The first lender, but only if they refile in the new state within a specific grace period. Explanation: under UC Article 9, 3168, when a debtor relocates or moves collateral to another state, the originally perfected security interest remains perfected for 4 months after the move. However, if the original lender fails to refile within this grace period, their security interest becomes unperfected as to competing creditors. New state option is incorrect because perfection does not automatically extend indefinitely across state lines. The first lender must take additional steps to maintain perfection after the move. Option B is incorrect because although the second lender perfected in the new state, their interest is subordinate if the first lender reperfects within 4 months. Option D is incorrect because a security interest is not lost due to a move, but it requires action, refiling, to maintain priority. Thus, the first lender retains priority only if they refile in the new state within the 4-month grace period. If they fail to do so, the second lender's interest becomes superior because it is the only properly perfected security interest in the new jurisdiction. Question 4. During a major transformation where existing methods of collateral management are being overhauled, a company seeks to restructure its secured transactions to optimize asset liquidity and reduce legal risks. The company has multiple types of collateral, including equipment, inventory, and accounts receivable. However, it is unclear whether certain security interests are perfected correctly. The company's creditors have varying claims, some of which based on purchase money security interest (PSI), while others rely on general floating liens. Considering the complexity of the situation, how should the company prioritize perfection methods to ensure maximum protection of its secured interests while complying with Article 9 of the UC? A. Perfect all security interests solely by filing a financing statement, as this is the only valid method of perfection under Article 9. B. Perfect security interests in equipment and inventory by filing, but rely on possession for accounts receivable to ensure priority. C. Use different perfection methods based on the collateral type. Filing for equipment and inventory, control for deposit accounts, and automatic perfection. PSI in consumer goods. D. Rely exclusively on control for all types of collateral, as this provides the highest level of protection in any secured transaction. Answer: C. Use different perfection methods based on the collateral type. Filing for equipment and inventory, control for deposit accounts, and automatic perfection for PSI in consumer goods. Explanation: under Article 9 of the UC, different types of collateral require different methods of perfection, equipment, and inventory. The most common method of perfection is filing a financing statement with the appropriate filing office. However, purchase, security interest, PMSIS in inventory require additional steps, such as sending advance written notice to other secured parties. Deposit accounts. Perfection occurs through control, meaning that the secured party has authority over the account. E.g., control agreement. Accounts receivable. These are classified as intangible collateral and must be perfected through filing. Perfection by possession is not an option for accounts receivable. Consumer goods. PAI. These are automatically perfected upon attachment without filing, provided they are for personal use rather than business purposes. Incorrect answers: A. Filing a is not the exclusive method of perfection. Other methods, control, possession, automatic perfection, may apply. B. Perfection by possession is not valid option for accounts receivable. D. Control applies only to specific collateral types. E.g., deposit accounts, investment property, and is not universal method. Question 5. In a multi-location scenario where consistency requirements must be maintained, a large retailer operates in multiple states and secures financing through a revolving credit agreement. The lender has a perfected security interest in the retailer's inventory, which is constantly replenished. However, competing creditor claims priority over newly acquired goods in certain states. The retailer also sells inventory in the ordinary of business, leading to questions about whether the secured party retains an interest in the proceeds. How does Article 9 of the UC govern these conflicting claims, and what steps should the lender take to maintain priority in the retailer's inventory and proceeds? A. The secured lender must file separate financing statements in every state where the inventory is located and rely on first-to-file priority rules. B. The competing creditor automatically has priority over new inventory if they filed before the retailer's secured lender. C. The secured lender should ensure properly perfected purchase money security interest (PSI) in inventory and file financing statement before the retailer takes possession. New inventory. D. The retailer's secured lender retains priority over proceeds automatically, regardless of how the inventory is sold. Answer. C. The secured lender should ensure a properly perfected purchase money security interest (PSI) in inventory and file a financing statement before the retailer takes possession of new inventory. Explanation. Under Article 9 of the UC, the priority of security interests in inventory follows special rules. General priority rule. The first to file or perfect rule applies, meaning that the secured creditor who files a financing statement first generally has priority, PSI super priority. A purchase money security interest (PSI) in inventory has priority over conflicting security interests if 1. The PAI lender files a financing statement before the debtor takes possession, and 2. They provide advance written notice to other secured creditors. Proceeds from inventory sales. A security interest continues in proceeds if they are identifiable and the statement covers them. However, if the proceeds are cash, the lender may need to perfect in deposit accounts by control to maintain priority. Incorrect answers. A. Filing in multiple states may be necessary, but priority is determined by the first to file rule and special PSI exceptions. B. A competing creditor does not automatically have priority unless they meet specific PSI filing and notification requirements. D. Security interest. Proceeds are not automatically maintained. The lender must ensure that proceeds remain identifiable and perfected. Question 6. While analyzing the root causes of sequential problems in secured transactions, a bank notices that several of its loan agreements contain improperly drafted security agreements. Some agreements fail to adequately describe the collateral, while others do not contain an authenticated record. A recent dispute arises where a debtor challenges the validity of the bank's security interest, arguing that it never properly attached. Under Article 9 of the UC, what elements must be satisfied for security interest to attach and become enforceable against the debtor? A. The secured party must give value. The debtor must have rights in the collateral, and there must be security agreement that describes the collateral in reasonable detail. B. Financing statement must be filed to establish attachment, and the debtor must provide written acknowledgement of the security interest. C. Attachment only occurs if the secured party physically possesses the collateral or has control over it, depending on the type of asset. D. The debtor sign an agreement specifically stating that they will not challenge the security interest in court for attachment to be valid. Answer A. The secured party must give value. The debtor must have rights in the collateral, and there must be a security agreement that describes the collateral in reasonable detail. Explanation. Under UCSS 9, 203, 3 requirements must be met for security interest to attach. Value must be given. This typically means the lender provides loan, extends credit, or provides some consideration. Debtor must have rights in the collateral. Must have an ownership or lawful possessory interest in the asset. Security agreement must exist. The security agreement must be authenticated, signed or electronically verified, and must reasonably describe the collateral, e.g. all equipment is sufficient, but all assets may not be. Incorrect answers. B. Financing statement is used for perfection, not attachment. Attachment occurs before perfection. C. Possession or control is not required for attachment. Properly executed security agreement is sufficient. D. Debtor's waiver does not establish attachment. Attachment depends on the 3 statutory elements under UCSS 9, 203. Question 7. During a major transformation where existing methods of collateral management are being overhauled, a company's secured lender reviews the effectiveness of its perfected security interests. The company has recently acquired additional equipment and inventory, but its prior financing agreements did not address after acquired property. If the lender wants to ensure that its security interest extends to the newly acquired collateral, what steps should be taken under Article 9 of the UC? A. The lender must amend its financing statement to include the after acquired property explicitly, as it is not covered by default. B. The lender should ensure that the original security agreement contains an after acquired property clause, as this is required to secure newly acquired assets. C. The lender automatically retains security interest in all future assets of the debtor, regardless of the language in the security agreement. D. The lender must file a financing statement within 30 days of the debtor acquiring new assets to maintain perfection. Answer. B. The lender should ensure that the original security agreement contains an after acquired property clause, as this is required to secure newly acquired assets. Explanation. Under UC SS 9, 204, secured party must include an after acquired property clause in the security agreement for newly acquired collateral to be covered. If the agreement lacks this clause, the security interest applies only to assets owned at the time of execution. Equipment and inventory. Well-drafted security agreement should specify that the security interest includes all equipment and inventory now owned and hereafter acquired. A financing statement. The UC1 filing does not need to be amended unless additional types of collateral are added. Exceptions. Certain assets, such as consumer goods and commercial tort claims, require separate agreements for after-acquired interests to attach. Incorrect answers. The financing statement does not need to list after-acquired property explicitly. The security agreement governs this issue. C. There is no automatic security interest in after-acquired assets unless the agreement states so. D. There is no requirement to refile within 30 days. Perfection remains valid unless other changes require a filing. Question 8. In a multi-location scenario where consistency requirements must be maintained, a lender finances a company that operates in multiple states. The debtor's main office is in California, but it has inventory and equipment in Texas, New York, and Florida. If the lender wants to perfect its security interest in the collateral located across different states, what is the most effective approach under Article 9 of the UC? A. File UC1 financing statement in every state where the collateral is located to ensure perfection. B. File in the debtor's state of incorporation or principal place of business, as this is where perfection is governed for most collateral types. C. Rely on automatic perfection for all equipment and inventory since they are tangible goods. D. Use possession as the primary method of perfection, as physical control over the collateral ensures priority in jurisdictions. Answer. B. File in the debtor's state of incorporation or principal place of business, as this is where perfection is governed for most collateral types. Explanation. Under UC SS 9, 301, the correct jurisdiction for filing UC1 financing statement depends on the type of debtor. Registered organizations, corporations, LLC, etc. The financing statement must be filed in the state of incorporation or principal place of business. Individuals, the filing is made in the state of the debtor's primary residence, fixtures, and real estate-related collateral. Filings occur in the state where the collateral is located. For company with assets in multiple states, filing only in the state of incorporation or primary location is generally sufficient. However, if the collateral includes fixtures or real estate interests, additional local filings may be necessary. Incorrect answers. A. Filing in state is unnecessary unless dealing with real estate-related collateral. C. Inventory and equipment require filing for perfection, not automatic perfection. D. Possession is not primary method of perfection for these asset types. Question 9. While analyzing the root causes of sequential problems in secured transactions, a bank realizes that several of its financing statements are about to lapse. Some involve long-term loans where collateral remains encumbered. Under Article 9 of the UC, how can the bank ensure continued perfection and maintain its priority status? A. File a continuation statement before the current UC1 financing statement expires. B. Refile the original UC1 financing statement after expiration to regain priority. C. Rely on the automatic continuation of perfection as long as the debtor has not changed jurisdictions. D. Require the debtor to execute a new security agreement and reperfect the interest. Answer. A. File a continuation statement before the current UC1 financing statement expires. Explanation. Under UC SS 9, 515, UC1 financing statement is valid for 5 years from the date of filing. To maintain perfection, continuation statement must be filed within 6 months before expiration. Priority protection. Timely filed continuation statement preserves the original priority date. Failure to file financing statement lapses, the security interest becomes unperfected, and the secured party loses priority against other perfected creditors. Incorrect answers. B. Refilling after expiration does not reinstate priority. It creates new security interest with new priority date. C. Perfection does not continue automatically. A continuation statement is required. D. New security agreement is unnecessary. Only continuation statement is required. Question 10. During a major transformation where existing methods of collateral management are being overhauled, a company discovers that its lender failed to perfect its security interest in a critical piece of equipment. The equipment has now been seized by another creditor who perfected their interest first. What options does the original lender have under Article 9 of the UC? A. Challenge the competing creditor's claim based on its original loan agreement, which predated the other creditor's interest. B. Attempt to perfect the security interest retroactively by filing a financing statement now. C. Seek subordination or negotiate priority agreement with the competing creditor. D. Demand immediate repossession of the collateral under self-help provisions of the UC. Answer. C. Seek subordination or negotiate a priority agreement with the competing creditor. Explanation. If a secured creditor fails to perfect its security interest and another creditor perfects first, the first to file or perfect rule gives priority to the properly perfected creditor. The original lender's best option is to negotiate subordination or inter-creditor agreement where the priority creditor agrees to subordinate their claim. Retroaffection. Filing late does not grant priority over already perfected interests. Repossession. Lender cannot use self-help if their security interest is unperfected or subordinate. Incorrect answers. A. The date of the loan agreement is irrelevant. Priority is determined by perfection. B. Retroactive perfection is not allowed under the UC. D. Repossession is not an option if the lender lacks perfected priority claim. Question 11. During a major transformation where existing methods of collateral management are being overhauled, a company decides to grant a blanket security interest in all of its assets to a lender. If the company later grants a second security interest in the same assets to another creditor, how will priority be determined under Article 9 of the UC? A. The first lender automatically retains priority, regardless of perfection. B. Priority is determined by the first to file or perfect rule, meaning the lender who files or perfects first has priority. C. The second lender can gain priority if it provides new value and the first lender fails to refile its financing statement. D. The lenders must negotiate a subordination agreement to determine priority. Answer. B. Priority is determined by the first to file or perfect rule, meaning the lender who files or perfects first has priority. Explanation. Under UC SS 9 322A1, the first to file or perfect rule determines priority between competing security interests in the same collateral. The secured party that either files financing statement first or perfects its interest first will have priority. Blanket liens. General secure interest in all assets does not automatically ensure priority. Perfection through filing is essential. Competing creditors. If second lender perfects before the first lender does, it can gain priority. Refiling requirements. If the first lender lets its acquon lapse, it may lose its priority position. Incorrect answers. The first lender does not automatically retain priority. Perfection is required. C. New value alone does not change the priority rules. Subordination agreements are optional, not required for determining priority. Question 12. In a multi-location scenario where consistency requirements must be maintained, a secured lender wants to perfect its security interest in a debtor's deposit accounts across several states. How should the lender proceed under Article 9 of the UC? A. File acquon financing statement in the debtor's state of incorporation. B. Obtain control over the deposit accounts by entering into control agreement with the bank. C. Perfect automatically upon attachment without any additional steps. D. File separate financing statements in each state where the debtor holds accounts. Answer. B. Obtain control over the deposit accounts by entering into a control agreement with the bank. Explanation. Under UC SS 9104, the only way to perfect security interest in deposit account is through control methods. The secured party must either be the depositary bank itself, obtain control agreement with the bank and debtor, have the account in the lender's name. Incorrect answers. And D. Filing acquon does not per security interest in deposit account. C. Perfection does not occur automatically. Question 13. While analyzing the root causes of sequential problems in secured transactions, a creditor finds that its debtor has changed its state of incorporation. How does this affect perfection under Article 9 of the UC? A. The creditor must file a new financing statement in the new state within 4 months. B. The original financing statement remains effective indefinitely. C. The security interest becomes automatically unperfected upon relocation. D. The debtor's relocation does not affect the creditor's perfected status. Answer. A. The creditor must file a new financing statement in the new state within 4 months. Explanation. Under UC SS 9 316A. 2. If debtor changes its state of incorporation, the creditor has 4 months to refile in the new state. After this period, the original financing statement becomes ineffective and the security interest is unperfected. Incorrect answers. B. The original filing is only effective for 4 months. C. Perfection does not end immediately. There is grace period. D. State change affects perfection and priority. Question 14. During a major transformation where existing methods of collateral management are being overhauled, a business that previously granted a security interest in its accounts receivable sells those accounts to a third party. What are the consequences under Article 9 of the UC? A. The secured party retains its security interest in the accounts despite the sale. B. The security interest is automatically terminated upon the sale of the accounts. C. The buyer must check for existing security interests or they may take subject to them. D. The buyer can demand that the original lender release the security interest. Answer. C. The buyer must check for existing security interests or they may take subject to them. Explanation. Under UCSS 9, 318, buyer of accounts receivable takes subject to any prior perfected security interest. The buyer must conduct UC search before purchasing accounts receivable to avoid potential conflicts. Incorrect answers. A. Security interest does not disappear upon sale. It continues unless released. B. The party's rights remain intact after the sale. D. The buyer cannot demand release unless the debt is satisfied. Question 15. In a multi-location scenario where consistency requirements must be maintained, a secured creditor has an interest in a debtor's inventory, which is being moved between warehouses in different states. How does this movement affect the security interest under Article 9 of the UC? A. The security interest remains perfected without any additional action. B. The creditor must file new UC1 every time the inventory moves. C. The security interest lapses if the inventory is moved across state lines. D. The creditor loses priority if another lender perfects in the new location first. Answer. 8. The security interest remains perfected without any additional action. Explanation. Under UCSS 9, 507, properly perfected security interest remains effective even if the collateral moves across state lines, provided that the debtor remains the same. Incorrect answers. B and C. The creditor does not need to refile for ordinary movement of inventory. D. Prior perfected lender maintains priority. Question 16. While analyzing the root causes of sequential problems in secured transactions, a lender discovers that its debtor has merged with another company. What should the lender do to maintain perfection? A. File a new UC1 financing statement in the new entity's name. B. Do nothing, as perfection continues automatically. C. Obtain new security agreement from the merged entity. D. File continuation statement. Answer. A. File a new UC1 financing statement in the new entity's name. Explanation. Under UCSS 9, 507 C, if debtor merges or changes its name, the secured party has 4 months to file under the new name. Incorrect answers. B. Perfection does not continue automatically after 4 months. C. New agreement is unnecessary. Only refiling is needed. D. Continuation statement extends an existing filing but does not update debtor's name change. Question 17. During a major transformation where existing methods of collateral management are being overhauled, a company grants a security interest in equipment and then leases the equipment to a third party. How does this impact the lender's security interest? A. The security interest continues in the leased equipment. B. The lease automatically terminates the security interest. C. The lessee takes free of the security interest. D. The lender must perfect separately against the lessee. Answer. A. The security interest continues in the leased equipment. Explanation. Under UCSS 9, 315A 1, security interest continues in collateral even if it is leased or transferred. Incorrect answers. B and C. The security interest is not extinguished by the lease. D. No separate perfection is required against the lessee. Question 18. During a major transformation where existing methods of collateral management are being overhauled, a lender discovers that its debtor has commingled its inventory, which is subject to a security interest, with other goods in a warehouse. How does this affect the secured party's rights under Article 9 of the UC? A. The security interest is automatically extinguished. B. The secured party maintains proportionate interest in the commingled goods. C. The secured party must refile financing statement to remain perfected. D. The secured party must obtain separate agreement covering the commingled goods. Answer: B. The secured party maintains a proportionate interest in the commingled goods. Explanation: under UCSS 9-336b, when collateral becomes commingled with other goods in manner that makes it impossible to distinguish, the secured party retains proportionate security interest in the resulting product or mass. Proportionate interest: if 40% of the goods were subject to the security interest before commingling, the lender now 40% interest in the mixed goods. Perfection continues. No additional filing is needed. Perfection continues in the proportionate share. Incorrect answers: A. The security interest is not extinguished, just proportionally. C and D. No refiling or new agreement is required. Question 19. In a multi-location scenario where consistency requirements must be maintained, a creditor with a perfected security interest in a debtor's equipment finds out that the debtor has moved the equipment to different state. What must the creditor do to maintain perfection? A. Nothing, because perfection continues indefinitely. B. File new financing statement in the new state within 1 year. C. File continuation statement in the original state. D. Repossess the collateral to avoid loss of priority. Answer: B. File a new financing statement in the new state within 1 year. Explanation: under UCSS 9-316A3, if debtor moves collateral to new state, the secured creditor must file financing statement in the new state within 1 year to maintain perfection. Grace period: the creditor remains perfected in the original state for 1 year after the move. Failure to refile: if the creditor does not refile the security interest, unperfected. Incorrect answers: A. Perfection does not continue indefinitely. C. Continuation statement extends an existing filing but does not help when collateral moves states. D. Repossession is not required if the creditor files in time. Question 20. While analyzing the root causes of sequential problems in secured transactions, a bank realizes that its debtor granted a security interest in the same inventory to multiple creditors. How is priority determined? A. The first secured party to file or perfect has priority. B. The most recent creditor always has priority. C. The first creditor to attach has priority, regardless of filing. D. All secured parties share equal priority. Answer: A. The first secured party to file or perfect has priority. Explanation: under UCSS 9-32281, priority is determined by the first to file or perfect rule. Filing versus perfection: the creditor who either files first or perfects first will have superior rights. Attachment alone does not win. Simply having an attached security interest does not grant priority. Incorrect answers: B. The most recent credited automatically get priority. C. Filing or perfection, not just attachment, determines priority. D. Priority is not shared equally. Question 21. During a major transformation where existing methods of collateral management are being overhauled, a company uses its equipment as collateral for a loan but later sells the equipment to a third party. What happens to the lender's security interest? A. The security interest automatically terminates upon sale. B. The security interest continues in the equipment unless released by the lender. C. The buyer takes free of the security interest in all cases. D. The security interest transfers to any proceeds from the sale but does not remain in the equipment. Answer: B. The security interest continues in the equipment unless released by the lender. Explanation: under UCSS 9-315A, security interest continues in collateral even after it is sold unless the lender expressly releases it or an exception applies. Buyer in ordinary course exception: if the buyer is purchasing in the ordinary course of business, UCSS 9-320, they take free of the security interest. Otherwise, the security interest remains. If the sales are outside normal business operations, the lender's security interest stays attached to the equipment. Incorrect answers: A. Security interests do not terminate automatically upon sale. C. Not all buyers take free of security interests. Only buyers in ordinary course do. D. The security interest continues in both the collateral and its proceeds. Question 22. In a multi-location scenario where consistency requirements must be maintained, a secured lender discovers that a debtor has relocated its principal place of business to another state. What should the lender do to maintain perfection? A. File a new financing statement in the new state within 4 months. B. Rely on the original filing as it remains effective. C. File a new security agreement with the debtor. D. Take possession of the collateral. Answer A. File a new financing statement in the new state within 4 months. Explanation. Under UCSS 9-316A2, if debtor relocates to new state, the lender has 4 months to refile in the new state to maintain perfection. Failure to refile? After 4 months, the original filing becomes ineffective. No need for new agreement. The existing security agreement remains valid. Incorrect answers. B. The original filing is only effective for 4 months. C. New agreement is not necessary. Just refiling is required. D. Perfection does not require possession unless it's possessory security interest. Question 23. While analyzing the root causes of sequential problems in secured transactions, a creditor finds that a debtor has defaulted. What are the creditor's remedies under Article 9 of the UC? A. Repossess the collateral without judicial action if it can do so peacefully. B. Repossess only with court approval. C. Automatically gain ownership of the collateral without further steps. D. Demand immediate repayment without any further rights to collateral. Answer A. Repossess the collateral without judicial action if it can do so peacefully. Explanation. Under UCSS 9-609, secured creditor may repossess collateral without judicial action as long as it does so without breaching the peace. Peaceful repossession. The creditor cannot use force or threats. Judicial repossession alternative. If peaceful repossession is not possible, the creditor must obtain court order. Incorrect answers. B. Action is not always required. C. The creditor does not automatically own the collateral. Foreclosure rules apply. D. The creditor can demand repayment but also has collateral rights. Question 24. During a major transformation where existing methods of collateral management are being overhauled, a secured party holding a perfected security interest in a debtor's inventory learns that the debtor has transferred some of the inventory to subsidiary company. What impact does this have on the secured party's interest, and what steps should be taken to maintain perfection? A. The security interest remains perfected, but the secured party may need to amend its financing statement. B. The security interest is extinguished because the debtor no longer owns the inventory. C. The secured party must immediately repossess the transferred inventory to avoid losing priority. D. The security interest automatically attaches to all assets of the subsidiary. Answer A. The security interest remains perfected, but the secured party may need to amend its financing statement. Explanation. Under UCSS 9-315A1, perfected security interest continues in collateral even after it is transferred, unless the secured party authorizes the transfer free of the security interest. Perfection status. The secured party's interest remains perfected, but if the subsidiary is a separate legal entity, secured party should amend its financing statement to reflect the new owner's name to maintain effectiveness under UCSS 9-507C. Proceeds. If the debtor received payment for the transferred inventory, the security interest automatically attaches to the proceeds under UCSS 9-315A2. Incorrect answers. B. The security interest does not disappear simply because the collateral is transferred. C. Repossession is automatically necessary if the security interest continues. D. The interest does not attach to all assets of the subsidiary, only the specific collateral or proceeds. Question 25. While analyzing the root causes of sequential problems in secured transactions, a creditor realizes that a debtor has granted a security interest in accounts receivable to multiple lenders. How is priority determined among these secured parties? A. The first secured party to file the financing statement has priority. B. The secured party with the earliest security agreement has priority. C. All secured parties share equal priority. D. The secured party who notifies the account debtors first has priority. Answer A. The first secured party to file a financing statement has priority. Explanation. Under UCSS 9-322A1, priority between conflicting security interests in the same collateral is determined by the first to file or perfect rule. Filing is key. The first party to file financing statement or perfect by another method e.g. control and deposit accounts will have priority over later filings. Attachment ordered matter. Even if another secured party attached first, priority still follows the first filing perfection. Incorrect answers. B. The security agreement's date does not determine priority. C. Priority is not shared equally unless explicitly agreed upon. D. Notification to account debtors does not determine priority unless the issue is assignment of accounts under UCSS 9-406. Question 26. In a multi-location scenario where consistency requirements must be maintained, A secured party has perfected its interest in the debtor's equipment. However, the debtor relocates the equipment to another jurisdiction. What actions must the secured party take to maintain perfection? A. File new financing statement in the new jurisdiction within 1 year. B. File continuation statement in the original jurisdiction. C. Take possession of the collateral immediately. D. File new financing statement in the new jurisdiction within 4 months. Answer: D. File a new financing statement in the new jurisdiction within 4 months. Explanation: under UC SS 9 316A2, if collateral is moved to new jurisdiction, the secured party must file new financing statement within 4 months to maintain perfection. Temporary perfection: the original perfection remains valid for 4 months. Failure to refile: if the secured party does not refile within 4 months, the secured interest becomes unperfected against new creditors. Incorrect answers: A. The grace period is 4 months, not 1 year. B. Continuation statement extends the financing statement but does not help when the jurisdiction changes. C. Possession is not necessary for non-possessory security interests. Question 27. While dealing with complex issues related to cross-collateralization, a debtor grants a security interest in after-acquired inventory to a lender. However, the debtor already has a loan secured by inventory from another lender. How does the after-acquired property clause affect priority? A. The original lender maintains priority over all inventory, including after-acquired property. B. The new lender gains priority and after-acquired inventory automatically. C. Priority is split equally between the two lenders. D. The original lender's priority applies only to inventory at the time of the agreement. Answer: A. The original lender maintains priority over all inventory, including after-acquired property. Explanation: under UC SS 9 2048, security interest can cover after-acquired property. However, under UC SS 9 32281, the first to file or perfect rule applies. After-acquired property clause: if the original lender's security agreement includes an after-acquired property clause, its security interest extends to new inventory automatically. New lenders have low priority. Later lender would be junior to the original lender unless they obtain subordination agreement. Incorrect answers: B. The new lender does not automatically gain priority. C. Priority is not shared. If follows first to file or perfect, the original lender's security interest extends to both existing and after-acquired inventory. Question 28. During a major transformation where existing methods of collateral management are being overhauled, a secured party discovers that its debtor has changed its legal name. What steps should the secured party take to ensure continuous perfection of its security interest? A. File an amended financing statement within 4 months. B. File a continuation statement in the original name. C. Do nothing if the original financing statement remains effective indefinitely. D. File a new security agreement with the debtor. Answer: A. File an amended financing statement within 4 months. Explanation: under UC SS 9 507C, if debtor changes its name to the extent that the existing financing statement becomes seriously misleading, the secured party must file an amendment within 4 months to maintain perfection. Incorrect answers: B. Continuation statement extends effectiveness but does not fix misleading name. C. If the name change is misleading, the original filing becomes ineffective. D. New security agreement is unnecessary. Just amending the financing statement is required. Question 29. While analyzing the root causes of sequential problems in secured transactions, a creditor finds that a debtor has defaulted. What remedies are available under Article 9 of the UC? A. Repossess the collateral without breaching the peace. B. Automatically gain ownership of the collateral upon default. C. Sue the debtor but not take the collateral. D. Demand immediate payment and ignore collateral rights. Answer: A. Repossess the collateral without breaching the peace. Explanation: under UC SS 9 609, upon default, secured creditor may repossess collateral without judicial action provided it does so without breaching the peace. Peaceful repossession: the creditor cannot use force, deception, or threats. Court involvement: if peaceful repossession is impossible, the creditor must seek court order. Incorrect answers: B. The creditor must still follow foreclosure or sale procedures. C and D. The creditor retains both payment and collateral rights. Question 30. During an extensive review of debtor-creditor relationships, a secured party discovers that its debtor has commingled cash proceeds from collateral, e.g., inventory sales, with other funds in a general bank account. How does this affect the secured party's interest, and what steps can be taken to enforce its rights? A. The secured party loses its interest because the proceeds are no longer identifiable. B. The secured party retains perfected interest in the commingled funds but must use tracing methods to claim its share. C. The secured party automatically gains control over the entire bank account. D. The secured party must file new financing statements specifically covering the bank account. Answer: B. The secured party retains a perfected interest in the commingled funds but must use tracing methods to claim its share. Explanation: under UCSS 9315, B. Security interest continues in identifiable proceeds of the collateral. However, if proceeds are commingled in general bank account, the secured party must apply tracing rules to determine its claim. Tracing methods. Courts often use the lowest intermediate rule liber, meaning the secured party can only claim the lowest balance in the account since commingling perfection in funds. If the secured party perfected its interest in proceeds, it maintains priority over unsecured creditors. Incorrect answers: A. The interest is not lost, but the secured party must trace the funds. C. The secured party does not gain control over the entire account, only the identifiable proceeds. D. No new fine statement is required unless the creditor wants security interest in the deposit account itself.